What is the difference between an I-130 interview and an I-485 interview? Hello, my name is Audra Doyle, and I'm the owner and attorney of Doyle Law here in Atlanta, Georgia. And I'm an immigration lawyer. This is all that I do. And I had a great question from a prospect last week. They said, what is the difference between those two interviews, an I-130 versus an I-485? So I'm going to share with you the difference today and make you aware how to prepare for both of those. Now, usually if you're filing a marriage-based application or a family-based petition and you're called for an interview, the officer will adjudicate both cases at the interview. Part of the interview will focus on the I-130, part of the interview will focus on the I-485. The I-130 is a family-based petition. To get a green card in the U.S., you have to show what is your connection here. The I-130 shows that there is a family connection. It could be marriage to a U.S. citizen. It could be brother, sister of a U.S. citizen, could be parent of a U.S. citizen, etc. So you have to prove that relationship, that connection to the U.S. citizen. Also, I-130s are used for permanent residence in a couple of instances. Now, the green card, on the other hand, that's the I-485 application for adjustment of status in the United States. And that green card does not focus on your relationship. It focuses on your ability to receive a green card. We call it admissibility. And so I'm going to show you some questions that they will ask you for that form. Now, for the I-130, if they say you have an I-130 interview today and it is based on a marriage-based petition, I recommend that both spouses go to that interview. If you have an I-485 application, it's based on a family relationship, a marriage, or a parent of a U.S. citizen, I do recommend that the sponsor attend the 485 interview. At the very least, they will have to sit in the waiting room. But I think that whoever is the sponsor, it would be very beneficial for them to be at the interview with you. Normally, when I receive an interview notice, so here's one here. This is a marriage-based case. And I know the I-130 is not approved yet, and it says request for applicant to appear for an interview, form I-485. On the notice, it says who should come with you. If your eligibility is based on your marriage, your spouse must come with you to the appointment. But at the top, it only says 485. However, they clearly want your spouse to be with you. So in all cases, for example, parent of a U.S. citizen, if they receive one of these, I am going to get that U.S. citizen to go to the interview. The I-130 portion of the case, they're going to focus on the relationship. So for parent of a U.S. citizen, they will make sure they really have the true parent there. Where was your child born? When was your child born? Name some family members in the family. If it's a marriage-based case, they're going to ask you about your relationship. And all those are focused on the connection between the applicant who wants a green card and the person who sponsored them. On the other hand, for the 485 part of the interview, they are going to be, again, looking at your admissibility. And I want you to think about, what does that mean? It means, have you done something to make it to where you cannot get a green card? And this is part of the I-485 form, these questions. If you filled in this form, you remember pages and pages and pages of questions. And all of these questions, it says inadmissibility. It's right there. That's what they're talking about. So for example, if you have been engaged in spying, espionage, if you have been engaged in trafficking of controlled substances, if you have been engaged in any sort of guerrilla group, terrorist activities, if you've had a J and you failed to serve your 2-year return home requirement, if you have been denied admission, it just goes on and on and on. All of these questions, if you are answering yes to some of these questions, then you may not be eligible to receive a green card. So if you notice when you're going through filling in your form, you have to say yes, that's the time to pause and make sure that you are going to be eligible for this. Sometimes when I do my consultations, I do not file green card cases for people who are not eligible. The most common reasons for ineligibility is folks who have criminal related issues or immigration related issues. So for example, they have a past removal order where they're supposed to leave the United States and they never left. Maybe they have an arrest and conviction for a crime where the law says they're not supposed to receive a green card and something's got to be done about that. Maybe we need a pardon or some other action needs to be taken. Another time when it gets a little tricky and we have to be careful is questions about military service. Several countries have required military service. South Korea, Israel, several of the former communist countries. I have plenty of clients that were old enough to be in the right age where they had to serve in the military back in the late 80s, early 90s, and we have to say yes. And we have to explain that to immigration. And I would say 90% of the time, it's not going to cause a problem because they were required to do it. They didn't have a choice. So that is the difference between those two interviews and the types of questions that you will be asked. Just keep in mind that for interviews in the United States, if you're getting, for example, this client, marriage-based case, it only says 485 here, but we're bringing the spouse, and I know that they're going to ask questions about the I-130 as well. So if you have any questions, please let us know. Don't forget to hit the follow button here on my YouTube channel and subscribe so that you can get updates when I post new videos.